We are really excited to have Archis join us today for a teleforum on our Atalese case. Archis Parasharami authored the amicus brief that we submitted along with the U.S. Chamber Litigation Center in appealing the New Jersey Supreme Court's decision in Atalese to the U.S. Supreme Court. He is a partner at Mayer Brown, co-chair of the firm's class action practice, and a member of the Supreme Court and appellate practice. He just writes and works extensively in this area and does a lot of writing of arbitration clauses that waive class actions and spends a lot of time defending those agreements in court. And we were really delighted to be able to participate in this process in appealing this, and really look forward to hearing what he has to say to all of us to discuss it. So I'm now going to turn this over to Archis.
Thanks very much. It's great to be with you. We're going to have, I think, quite a bit of time for questions and answers, and I want to make sure we do have that time. But I want to give a brief overview of some of the case law and policy in the area of arbitration before getting to the Atalese case. So I assume everybody on the call has some familiarity with arbitration, but I like to start with first principles, which is why arbitration in the first place. And the answer is that at least in some circumstances, arbitration has significant advantages. It reduces transaction costs. It's less adversarial than litigation. And it's a fair and expeditious process for resolving disputes. That process is one that has had congressional support for a long time. In 1925, so that's, 90 years ago, the Congress enacted the Federal Arbitration Act to reverse what was at the time a long-standing judicial hostility to arbitration. In the bad old days, and as we'll see even today, many courts thought that they should be the ones that decided legal questions, and that assigning those questions to a third party was an impermissible intrusion on their power. And I think I understand that judges are important, but they aren't the only people who can resolve disputes. And for a long time, nonetheless, many courts thought that it was important to guard their jurisdiction. So Congress changes all of that in 1925 by adopting the Federal Arbitration Act. And the key centerpiece of that statute is Section 2 of the FAA, which provides that arbitration agreements that are written must be enforced unless there is a generally applicable rule of state law that would authorize invalidating any contract. I'm not quoting from the statute, but that is the core of what Section 2 of the FAA means. And for a long time, arbitration was mainly business to business, but over time, and especially starting in the 1980s, the Supreme Court had a continuing and growing trend towards endorsing arbitration. And this resulted in an increased use of arbitration by many businesses, not just in a business-to-business context, but also in the consumer and employee setting. That began, I would say, to grow and strengthen in the 80s, and then really hit its stride in the 90s and 2000s. Many courts enforced arbitration agreements, but some did not. And the courts that did not looked for all sorts of reasons to invalidate arbitration. Both federal and state courts, in some cases, enforced them, in some cases didn't, but there was, I would say, a more meaningful amount of hostility to arbitration developing in the state courts. The Supreme Court, over time, has been rejecting that hostility. And so I want to talk about a couple of issues. I think that the one that I think it's not really presented by Atalese, but it is in the background, is the fact that the arbitration agreement at issue in that case, and in many cases, waives class action. I think that it used to be, especially in the 90s and early part of the 2000s, that there were arbitration agreements that were arguably unfair as written to individual consumers and employees. Courts were striking them down on the ground that either they only allowed the company to go to court, but they allowed the plaintiff or mandated the plaintiff arbitrate. They might allocate fees in a way that was arguably unfair to plaintiffs. There might be limitations on the remedies available to plaintiffs, things like that made arbitration arguably a less favorable forum on an individual basis than court would be. A few courts have held those arbitration provisions, but many struck them down, applying state law rules of unconscionability. And I think many businesses began to understand that they benefited from having arbitration provisions that provided fair individual resolution because both sides were better off than being in court. But at the same time, maintaining what is a key centerpiece of many arbitration agreements, which is requiring that arbitration take place on an individual basis instead of on a class-wide basis. This group of lawyers in the audience, I think, knows very well, probably better than me, why there are significant detriments to class action litigation and why class actions impose massive transaction costs that don't benefit either businesses or their consumers or employees. And, I benefit from them as a lawyer who defends companies in class actions, and certainly the plaintiffs' lawyers who bring class actions benefit from them when the class actions are successful. But I think it's at least a fair criticism of class actions that a legal system where the winners are the lawyers rather than the parties is something to be worried about. And my sense is that that's an important aspect of what the New Jersey Civil Justice Institute is all about, which is trying to bring some rationality and legal reform to litigation. And arbitration is, I think, one way of doing that, of bringing some rationality by replacing the troublesome class action system with all of its flaws with a fair method of individualized dispute resolution. And so what you saw in the 2000s and in this decade has been that businesses have made arbitration provisions increasingly favorable to employees and consumers so that everybody has a fair shake in those individual disputes, but that as part of the trade-off, the parties agreed not to have class procedures. As you can imagine, many courts didn't like this, and especially courts in California and New Jersey were among the first and most prominent movers in this area. I think a lot of judges adhere to what I think of as a law school or theoretical notion of class actions that, if you talk about class actions in the abstract, it seems like it might make sense. You bring together large groups of individuals all resolving the same issue. Everybody wins in terms of having greater efficiency, and it facilitates the resolution of small claims. But in practice, we know that isn't how it shakes out, that very few individuals actually make claims in class actions, that very few class actions even proceed to the class certification stage, and virtually all of the ones that do settle. So there aren't any class action trials. So the notion that claims are being tried together is false. Having said that, I think that the reality of class actions is one that many judges hadn't in the past, and certainly even today, I think don't really, take to heart. And so I think many are still thinking of it as this theoretical construct that really first came to fruition with the 1966 amendments to Federal Rule 23, which many states have since followed. So that's just a long way of saying lots of courts, especially state courts, didn't like class actions. And in New Jersey, as many of you know, the most prominent case is Muhammad versus County Bank of Rehoboth Beach, Delaware, where the New Jersey Supreme Court declared that class waivers were unenforceable. So the next major development was AT&T Mobility versus Concepcion. And that was a case that my colleagues and I handled from the trial level through to the Supreme Court. And I will be pretty brief on that because I suspect anybody who is interested in this call has heard about it. But just to say what happened in that case, AT&T Mobility, the wireless company, had a very favorable arbitration provision that provided consumers with powerful benefits to arbitrate on an individual basis. So much so that the district court found that the Concepcions, the named plaintiffs, would be better off in arbitration than they would be in bringing a class action. Typically, a arbitration clause or any other contract that's unconscionable has to be so unreasonably favorable to the business that, or to the stronger party, that it would be utterly unfair to enforce it against the individual party. And so when you have a finding from the court that the named plaintiffs are going to be better off, you would think that couldn't be unconscionable. But both the trial court and then ultimately the Ninth Circuit said, I'm paraphrasing, of course, but it doesn't matter how favorable this is to the individual. California has a policy in favor of class actions, and that policy trumps the right of the parties to contract for individual arbitration. And basically that was the same rule that the New Jersey courts had announced in Muhammad. So we petitioned the Supreme Court for cert and got review, and in April 2011, the Supreme Court ruled in favor of AT&T 5-4. And the key elements of that holding were, first, that California law, and you can, for all of this, just insert New Jersey law because they were essentially the same, was preempted under the doctrine of conflict preemption. The court reasoned that the Federal Arbitration Act has a particular kind of arbitration in mind, one that is speedy, efficient, saves money. And it noted that class arbitration is essentially a different animal. It's so different from individual arbitration that it essentially removes all of the benefits of individual arbitration. And so the core holding of the Supreme Court's decision is that requiring the availability of class-wide arbitration interferes with fundamental attributes of arbitration and thus creates a scheme inconsistent with the FAA. So that's what the Supreme Court held. As a result of that, what has happened since Concepcion has really been a sea change where arbitration agreements that used to be unenforceable simply because they contained a class waiver, like the arbitration agreement in Atalese, that used to be struck down all over the place, especially in California, New Jersey, Washington State. There was something like, I don't remember the exact number, but probably 10, 15 states that were routinely striking down arbitration clauses. But that took on outsized importance because if you're a plaintiff's lawyer who knows that a state won't enforce an arbitration agreement, you file your class action there. And so California is famously a hotbed for class actions, but New Jersey is not too far behind, and I'm pretty sure I'm preaching to the choir on this one. I've had many class actions in New Jersey, and it has been thought of, I think, by plaintiff lawyers as a hospitable forum, and it has a very active plaintiff's bar. So Concepcion, a pretty dramatic sea change. It makes arbitration agreements that require individual arbitration now enforceable. At least they can't be struck down on the ground that they waive class actions. And so this is all leading up to how we get to Atalese. After the fairly easy layup that plaintiffs had of getting arbitration clauses struck because they had class action waivers, after that was taken away, plaintiffs lawyers who are creative and always looking for the next way to make their arguments said, well, how can we still attack these arbitration clauses? And they looked at a number of ways, but one or a couple of ways I think that they focused on, and with some success, is one, are people forming contracts? They used to not fight over whether a contract was formed. That was generally assumed. Now they're much more likely to fight over whether the parties actually entered into a legally binding contract. And as a corollary to that, and this is Atalese, the plaintiffs have argued that an arbitration clause can't be enforced if it is not given sufficient notice. And it's hard to tell what that means, but there is a background principle that the plaintiffs have had to fight against, and that comes from a Supreme Court case called Doctors Associates versus Casa Rota, decided in the 1990s. So I want to talk about that case because it was at the heart of our amicus brief in Atalese. In Doctors Associates, this 1996 case, the Montana legislature had passed a law that said that arbitration agreements had to be on the front page of any contract, and it had to be in special type. So according to the Supreme Court, the contracts containing arbitration clauses had to declare that fact in underlined capital letters on the first page of the contract, kind of a special warning seal. Watch out, this contract contains arbitration. That's what Montana said needed to happen. And the Supreme Court, by an 8-1 vote, overturned a Montana Supreme Court that had upheld that statute. So not controversial at all that this legislation was problematic. Why? Because the notion that you need a special warning about how scary arbitration is, which, by the way, I think is a myth that's been perpetuated by the plaintiffs' bar unfairly in recent years, especially since Concepcion. But it was ongoing in some places, such as Montana, even before Concepcion. But that special warning singled out arbitration for suspect status, as the Supreme Court has said. It really reflected, in this case, legislative, not judicial hostility to arbitration, but a state's hostility to arbitration. And it did not apply to all contracts generally. And I mentioned at the beginning of the call that the Federal Arbitration Act requires the enforcement of arbitration agreements, except if there is a generally applicable ground for refusing to enforce the agreement. In the phrases of the FAA, it's for the revocation of any contract. And so there are some reasons to refuse to enforce an arbitration agreement that are, I think, uncontroversial, that would also apply to other contracts. No contract is enforceable if you hold a gun to someone's head. The doctrine of duress says that's not enforceable. And that applies both to a contract for, buying a computer or a contract to arbitrate. And those aren't different legal principles. There may be principles, for example, that relate to whether minors, children under 18 can enter into contracts, and the same rules presumably would govern whether they can enter into arbitration agreements. So there are all sorts of contract rules that are generally applicable that could apply, and even unconscionability, if applied fairly in the way that it's applied to all other contracts, could be applied to arbitration, as the Supreme Court has recently said. But what can't be done is to apply special rules to arbitration, special contract law rules, or other state law rules to arbitration that don't apply more broadly. And that's what the Supreme Court said about the Montana statute in Doctors Associates, that the state's law directly conflicted with Section 2 of the FAA because the state's law conditions the enforceability of arbitration agreements on compliance with a special notice requirement not applicable to contracts generally. Okay, so that seems like a pretty straightforward rule. And then turn to Atalese. In Atalese, the New Jersey Supreme Court confronted an arbitration agreement that required the arbitration of essentially all relevant disputes. But the New Jersey Supreme Court observed that it did not contain additional warning language stating that consumers are giving up their right to seek relief in a judicial forum. And what the New Jersey court said is that when that special warning isn't present in the arbitration agreement, then it's as if there is no mutual assent between the weaker party and the stronger party to arbitration, and this fact renders the arbitration provision unenforceable. What kinds of special warnings was the New Jersey Supreme Court looking for? They were looking for things like saying that arbitration meant not going to court and not having a jury trial. But what's interesting is that contracts contain all sorts of complicated language, and I would say that not every word in a contract is fully defined, and if we required that, our contracts would not be 3 or 5 pages, which some might say are already long. They would be telephone books. And does that really give people any meaningful notice? I think the answer has to be no. So it has to be that what the New Jersey Supreme Court was doing was erecting a special notice requirement that applied to arbitration alone, based on an assumption that there was something problematic about arbitral dispute resolution. Nonetheless, the New Jersey Supreme Court protested that it wasn't really doing that, that its rule was generally applicable to all contracts, and it was just basically an arbitration-specific version of the rule that waivers of rights, of certain statutory rights, had to be expressed. And I just want to talk a little bit more about this denial, because you see what was interesting. So in writing this amicus brief, I decided to watch the oral arguments, and there I think the court was actually, although you didn't see it in the opinion, quite a bit more aware of the overhang of the Federal Arbitration Act. So they kind of knew, I would say, that they were operating under a principle that required equal treatment of arbitration clauses and other contracts. So what they said was, we haven't really prescribed a set of words that are needed to form an arbitration agreement, but whatever words compose an arbitration agreement, they must be clear and unambiguous that a consumer is choosing to arbitrate disputes rather than have them resolved in a court of law. And they also went on to say that even though the arbitration agreement clearly and unambiguously stated that any dispute related to the underlying agreement should be submitted to arbitration, and that the resolution of that forum shall be final and binding, essentially saying there's a different forum than court, and it will be a final and binding resolution of your claim. The New Jersey Supreme Court says not good enough. That clear and unambiguous statement is insufficient because, quote, an average member of the public may not know, without some explanatory comment, that arbitration is a substitute for the right to have one's claim adjudicated in a court of law. Recall, as I said before, that under Section 2 of the FAA, any contract law rule that a state applies to contracts, to arbitration agreements, has to apply to all contracts generally. So you can take out any contract you have that's a consumer and employment contract, or any other contract for that matter, and if you had to review those contracts and see whether every word in it was one that an average member of the public may not understand without some explanatory comment, as I say, I think you enter the world of telephone book-sized contracts, not short, plain contracts that consumers, if they don't understand it, can look for additional information. I think that if this special notice requirement were genuinely applied to all aspects of contracts, you would see a very different world of contracts. And I think you're not seeing that it's being applied outside of arbitration. This is a rule that is being applied specifically in the arbitration context. So the company in Atalese decided to seek Supreme Court review. The petitioner's U.S. Legal Services Group, and we here as the New Jersey Civil Justice Institute and the Chamber of Commerce of the United States filed an amicus brief in support of the petition for cert. And we argue that this New Jersey state rule, by essentially demanding a special warning label for arbitration agreements that doesn't apply to all other contracts, is in violation of Doctors Associates versus Casarota, the case involving the Montana statute that I described before. And that it's such a clear violation that the Supreme Court not only should overturn it, but it should do so summarily, that it's such an obvious violation that the Supreme Court should say, we don't even need to hear oral argument on this. The briefing on the cert petition is enough. And accordingly, this state court defiance of federal law and the Supreme Court's precedent should be overturned. And that may sound like an ambitious request, but I'm here to tell you that the New Jersey Civil Justice Institute and the Chamber are doing the right thing, in my view. I'm biased because I'm advising them, but I think this request is on solid footing. And the reason is that the Supreme Court has unfortunately had to do it essentially four times in a row between 2011 and the present. There have been 4 cases arising out of either state intermediate appellate courts or state Supreme Courts, where either out of a lack of knowledge, but I think more likely a hostility to arbitration, the state courts have simply not followed the dictates of the Federal Arbitration Act and the U.S. Supreme Court precedents, and the Supreme Court has stepped in and on these 4 occasions summarily reversed the state court. So there's a case called Nitrolift Technologies versus Howard in 2012, where the Supreme Court reversed an Oklahoma Supreme Court decision that, quote, disregarded this court's precedents on the FAA in an area relating to whether certain provisions are severable from others. It's not a particularly interesting legal issue, but the Oklahoma court clearly got it wrong. There was a Florida Intermediate Appellate Court that had, quote, failed to give effect to the plain meaning of the Federal Arbitration Act and to a 1985 Supreme Court holding. And so in 2011, the U.S. Supreme Court summarily reversed that. In the Marmot case, which is the case that I worked on, the West Virginia Supreme Court of Appeals had declared that personal injury and wrongful death claims are simply not subject to arbitration. But the Supreme Court has said on probably 4, 5, 6 occasions that states can't declare certain types of claims categorically off limits to arbitration. I should say that the Marmot case was a particularly, I think, straightforward cert petition to write because the West Virginia Supreme Court was so direct in its disregard of the FAA that it actually said that the Supreme Court's jurisprudence in this area was, quote-unquote, tendentious, which, I've got to think if you're a Supreme Court justice and you read essentially a lower court saying that about your work, you might not think too fondly of that state Supreme Court. Now, I think that, and we got a unanimous summary reversal in that case. Now, I think in Atalese, I wouuld say that the New Jersey Supreme Court was as overtly disrespectful. I think. Maybe this is just my I grew up on Long Island, spent time in New Jersey. My sense is that the New Jersey Supreme Court maybe was a little bit more sophisticated about how to approach this. So they were wise enough not to declare the Supreme Court's jurisprudence tendentious. But you kind of wonder whether that's what they think. Because when you read this opinion, in my view, it simply can't be squared with Doctors Associates versus Casarota or a wide range of other cases. It really does, in my view, ignore that you can't, as the Supreme Court put it in Doctors Associates, impose special notice requirements on arbitration agreements. The Doctors Associates case says specifically, state legislation requiring greater information or choice in the making of agreements to arbitrate than in other contracts is preempted. And what is the Atalese rule if not that? So I want to pause there, both to take a breath and also to see if there are questions before I kind of talk a little bit further about this. But why don't I take a moment and just see if there are any questions?
Do you have any sense of the timing on a response from the Supreme Court?
Yeah, that's a good question. I mean, the rough answer is somewhere in the middle to late May, unless they summarily reverse, in which case it will happen. What happens in the cases where there are summary reversals is that the date when they're scheduled to announce a decision on whether to grant cert or not kind of goes by, and then you look on the docket and you see that the court has either relisted it for consideration at another conference, which is a conference is the meeting of the justices. They meet on a regular basis to decide whether to take what actions to take on cases, or it just kind of is sitting out there, which means that perhaps the court, if somebody is writing an opinion. So we won't know that for a while, but
probably the end of May.
Probably know by late May or early June.
Hi, thank you. I was curious what you think about how difficult it might be to contain the harm of Atalese. How damaging of precedent is it to have this out there?
If the Supreme Court doesn't step in, I think it would be very damaging. It is true that at least some companies have the kind of warning language that the New Jersey Supreme Court calls for, notwithstanding that in my view, the Federal Arbitration Act doesn't require it. But not every arbitration clause does, and so it's not as if you can press a button and change existing contracts. So that would put at risk a wide array of contracts already, just under Atalese alone. But I think what's actually more troubling about it is that if it's not, I hesitate to use the word slap down, but maybe that is what I should say. If it's not reversed and resoundingly so, it almost invites other state courts to engage in similar mischief. And, it would be one thing if the Federal Arbitration Act prescribed some magic words prospectively. Most companies could deal with that. But it's another thing if 50 different states have 50 different versions of what they think is the right kind of notice for arbitration agreements. How can a company that acts nationally comply with that? And then even if you're in a specific state, where if your operations are limited to a single state, whether it's New Jersey or somewhere else, I guess you have to ask what's next. If you need to say what arbitration is and explain that it means waiving your right to a jury trial, which many courts, by the way, have said is literally they use the sort of an obvious consequence of agreeing to arbitrate. So if you have to spell out things that most courts would consider obvious, where's the limit? How long? And I tend to think, some plaintiffs' lawyers and their allies who have challenged arbitration agreements say that arbitration agreements are long and hard to read already. So what would this rule do? It would make things worse, not better. I actually spent a lot of time writing arbitration agreements for businesses, and a lot of times I think business people who are very human and sensible say things like, well, could we make this shorter because I want my customers or employees to be able to read it and understand it carefully. And sometimes we can do that, but sometimes we can't, and the reason, or at least we advise against doing so, and the reason we do that is we say, the reason that I have these 10 sentences in the agreement is because there are 10 different challenges, literally, that I can point to that I've litigated that plaintiffs have raised, and so these sentences resolve those problems, which ultimately saves the company money by not having to litigate over these issues. And sometimes they're not very impressive arguments, but they cost money anyway. And that's why I just think that this Atalese decision potentially opens the door to much more of the same. Longer arbitration provisions that actually provide consumers and employees with less notice or less meaningful notice. Is this decision on its own all that harmful? I think it is. I think it's pernicious. But I think what's far worse is what it might lead to if not checked. I hope that's a helpful answer.
Hi, I had a question about the justification that the New Jersey Supreme Court gave to the point that they weren't treating arbitration clauses differently because they apply this sort of super special requirement to all manner of contractual waiver of rights provisions. And then they have a list of examples where they suggest which they seem to suggest are analogous to this situation. And I just was curious what you thought about the analogies that they're drawing there. A lot of them seem to have seem to relate to labor-related agreements, and I just wondered if you had any other thoughts, if there's a sort of a suggestion in this context that what they mean by that is sort of waivers that are sort of deemed against public policy, or if that's too strong an interpretation.
I think that's a good point. I think if you were trying to defend what the New Jersey Supreme Court did, which the respondents will try, I think what they would say is that this isn't limited to arbitration. This rule sweeps more broadly and is a rule that's really, like you said, about public policy, about the waiver of statutory rights, and that any waiver of statutory rights has to be called out specially. So this is not just arbitration specific. But I guess I don't think that is a fair assessment of what's going on, because the Supreme Court has been pretty clear that arbitration isn't a waiver of, at least a substantive waiver of rights. Arbitration is a waiver of a forum. So the whole point of arbitration is that you have the same substantive rights just pursued in a different forum. And so I think that the effort to say that this is just like, I would get a rule, and I'm not sure I would even oppose a rule that says, like, let's say, by agreeing to work at company X, I waive all of my rights under Title VII and the New Jersey law against discrimination and the like, right? I'm not sure if that would be enforceable anyway, and my guess is that there would be some serious questions about that, but I can also understand a rule that says, if you're going to do that, put that in extra bold type, because that would be really surprising. But that's because somebody would be losing a substantive right. And I think the Supreme Court has been pretty clear that arbitration isn't the same kind of substantive right, that, the New Jersey Supreme Court seems to say that jury trials are essentially superior to arbitration as a method of dispute resolution. But the FAA says you can't actually say that, states, because if you say that, that means that you're singling out arbitration for suspect status. And that's why I think that the effort by the New Jersey Supreme Court to defend its rule is ultimately unconvincing. But I don't know whether that sounds convincing to you.
Yeah, no, I think that makes a lot of sense. I mean, the sort of the first step is, yes, but you need to distinguish between the waiver of substantive rights and a procedural waiver. And then the second is, and even putting this in the category of that exists in a sort of generally applicable way of waivers that we deem to some degree against public policy is itself not an option that you have on the table because you don't get to call arbitration against public policy, right?
Yes, exactly right. I mean, you could probably do it for almost anything else, but what you can't do is declare arbitration against public policy, and because that is the kind of hostility to arbitration that the FAA was enacted to prohibit some 90 years ago.
Right. So even putting it in that basket where you get to sort of on the surface make an argument that you're not singling out arbitration, the fact that you're putting it in that basket is also itself illegitimate.
Right, exactly. And so you're talking about the line in the opinion that says we impose no greater burden on an arbitration agreement than any other agreement waiving constitutional or statutory rights. That begs the question.
Exactly.
Waiving it in the same way, except in a way that's arbitration hating, which for the reasons you described can't be permissible.
I was wondering if you could talk a little bit about how this decision by the New Jersey Supreme Court has already impacted New Jersey law.
Yeah, that's a great question. So we are already seeing that the Atalese decision is being cited in a number of other cases in New Jersey for sure. So I'm just looking for the names of the cases, but I know that there have been at least two, I believe, appellate decisions that have three decisions that have essentially applied Atalese and refused to enforce arbitration agreements that are clear and unambiguous that they require arbitration because they don't have that special warning. So there's an arbitration clause that says any disputes arising in connection with this agreement shall be heard and determined by arbitration before a single arbitrator, and the decision of the arbitrator shall be final and binding. That seems pretty clear to me that a dispute will be resolved by arbitration. And maybe I'm the wrong person to test it out on because I write these, but I think if you asked anybody else, what does that mean? They would say it means an arbitrator decides questions, and the obvious consequence of that is that it means it's not going to court. But that fails under Atalese, according to the New Jersey Appellate Division. There's two other cases that basically have very similar language in the arbitration agreements. This case, October 24th, Rosenthal versus Rosenblatt, an agreement that says all disputes shall be exclusively resolved through mediation and arbitration. That doesn't succeed because the agreement, according to the Appellate Division, fails to include the language our Supreme Court has deemed crucial to an effective waiver of the right to litigate in court. So basically, you've already seen, and there's a third case that I won't talk about in detail, but you've already seen three cases in a matter of months that at the appellate level that have struck down arbitration agreements. And if cert is not granted in this case, it will just continue.